Good evening. This is John Milburn for Laws 11059, Statutory Interpretation. We're into Week 6 of Term 3, 2018. Thank you very much, those that are attending the live session. We have the results of the first assessment coming back to you soon, and I'll provide some feedback. I provide feedback in a number of ways. One is audio feedback, and I'll typically do that for some of the live sessions. So for example, I take evidence and proof, and when we have a live cross-examination or examination session, I'll usually provide oral feedback. Sometimes I take your paper and I'll mark it up with my notes, which is, I guess, fairly conventional, the red pen style marking of feedback, and I use that approach quite often also. Another approach that I adopt is to provide you with a document that I prepare, and in that document I provide you a combination of information about what I'm looking for, to some degree some of the key points, not a model answer, and some commentary in relation to your work. So there are different styles of feedback, at least that I use, and please let me know as we progress which type of feedback you favour, which type of feedback provides you with the best learning experience. Week 6, Intrinsic Materials Statute Components. The first thing is to properly identify and understand some of the differences in terminology. And as we mentioned in Week 1, there are some key words in statutory interpretation, and as part of your toolkit, as part of, if you like, the second assessment, you need to identify these key words and attribute a meaning that works for you and have some authority for your propositions. Let's look at some key words: purpose and intent. Statutory purpose focuses on the why and the who. Statutory intent focuses on the what and the how. So purpose looks at why the legislation is needed and to whom it is directed. And intention is concerned with what is done to meet the purpose and how it should be implemented. So you can see from that that intention is more of a mechanical process, and purpose is addressing historical issues and creating something new as a result. Another key issue that you would have identified during statutory interpretation so far is a very fundamental thing, and that is that we simply can't read the words of a section of an Act and apply those words without looking at the words of surrounding sections and indeed the Act as a whole. As authority for that proposition, consider the case of K&S Lake City Freighters against Gordon and Gotch, 1985, 218, CLR 216. And you'll see that case feature in your textbook. So from that, again, the next extension of your toolkit should be a series of quotes that meet different purposes and authority for those quotes, typically from a case, but it can be from a textbook or some other source. So that when you're preparing your assessment in statutory interpretation, or indeed any legal assessment, you're providing some rationale for your decision and you're supporting it with the authority. Very important to do both those things. One of the great things about statutory interpretation is that if you complete this task well during this unit, it will serve you very well for other units. It will give you a head start when you're dealing with other units. Say, for example, in constitutional law, and you're dealing with the interpretation of constitutional sections of a constitution, you can rely on some of the work that you've done in statutory interpretation to assist you in providing a good answer for constitutional law. So what I want you to do is develop a toolkit that works well beyond this unit, something that you will refer to in years 2 and 3, and indeed in practice or beyond. I hope that makes sense. So do the toolkit well, have your basic sections done correctly. Now, let's just have a look at that statement that I made, the quote, if you like, from, or the authority for the proposition that I gave from K&S Lake City Freighters. And that is the High Court saying, you can't simply read the words of a section and apply them without looking at the words surrounding and indeed the act as a whole. I have a little problem with that. Now, this is a practical problem that I've got. And this comes from the perspective of a practitioner. So picture yourself as a first-year law student, for example. A client comes to you and asks you a legal problem. You do some research and you quickly identify that, let's say, Section 55 of the Property Law Act answers the problem. Now, it might be tempting to immediately say, the answer to the problem is this, and my authority is Section 55 of the Property Law Act. I've just taken a section at random. And that might be a task that you can complete in 15 minutes, and you might bill it accordingly. But if you take those words of the High Court, perhaps literally, then you may spend more than 15 minutes in reading that section, because you need to consider the surrounding sections, you need to consider the headings, you need to consider the act as a whole, and if you take it further, you may need to consider both intrinsic and extrinsic materials. So suddenly, the response that perhaps the client expected might take 15 minutes, or just as importantly, your employer might have expected to take 15 minutes, you're writing 2 hours on the timesheet and saying, I had to read the surrounding sections, I had to read the entire act, I had to consider intrinsic material, and I had to consider extrinsic material. Therefore, instead of rendering a bill for $80, here is my bill for $540. So do you see the essential problem here in actually applying what we're teaching you in a practical setting? So with my lecturer's hat on, I'm saying this is what you must do, and this is how you must answer the problems that are presented to you at university. But with my practitioner hat on, I'm saying just be a little careful about going overboard. And I know that some students who work in practice have some difficulty with that transition because they haven't yet adopted and implemented the commercial imperatives, if I can use that term of practice. Now, having said all that, have I confused you or helped you? Because I do hope it helps without compromising the quality of the work that you need to produce. Any questions about that essential dilemma that I've discussed? All good? All right. Now, of course, some sections may be read using their ordinary meaning. Other sections, you may not be able to do that. You may have to sometimes read more broadly, or you may have to read the section more narrowly. And it depends on the context. And this is all part of considering the intrinsic materials. The intrinsic materials being that which is contained within the legislation. Can anyone tell me if they've come across this difficulty, that there may be conflicting sections within an act, or perhaps within an act and the corresponding regulation, and you need to work out in those circumstances which applies? Has anyone come across a case that dealt with that sort of issue? I suspect you have. Let's see who can put it on the chat facility. Blue Sky, very good. Project Blue Sky. And in Project Blue Sky, the court adopted the attitude that some may be leading or dominant sections, others will be subordinate. And we'll talk more about that pretty much every week, but more in week 7. Okay, so let's go through the intrinsic materials of legislation. I suspect by now this is all pretty basic, and I do hope that you've read the material in the chapter for this week. always make sure that you're reading ahead and you're reading well in advance if possible. So the long title, traditionally legislation includes both a long title and a short title. And let's take, for example, if you've got Ausley or legislation Queensland, the Mental Health Act 2016. We'll use that as a working example for the moment. If you're watching this as a recorded session, please call up the legislation and have a look at what's there. So can anyone tell me from the Mental Health Act 2016, what is the long title for that legislation? What do the words say? You can use the chat facility or you can unmute your microphone. There it is. Oh, Gareth, are you using voice recognition or did you type that quickly? Very good, Gareth. An act, cut and paste. Oh, even better, of course. An act to provide for the treatment and care of people who have mental illnesses and for other purposes. Have we all now found that? You'll find that on page 37, I believe, of the Act. This is an interesting Act in that the index is very long. It's a very complex piece of legislation, but that's the long title. Now, the short title is simply the Mental Health Act 2016. That's the citation that we're authorised to use. Now have a look at the objects clause of that piece of legislation. You don't have to look far, it's section 3. And you'll see that the main objects are identified as A, B and C. Let's have a look at those objects and compare them with the long title and see if there's a difference. It may be subtle, it may be not so subtle. So read the long title and now read the 3 objects, the main objects, which is section 3, subsection 1. Can anyone tell me if they believe the 2 are consistent, the long title and the main objects? Is there a difference? Any thoughts? Again, if you're watching this as a recorded session, please go through the exercise. Let's look at the long title. Gareth identified it. So Tim says, yes, they're linked. Gareth said similar, but the objects also allow for the safety of others. Yeah, that's the point that I was looking for. So thank you, Gareth. So when we look at the long title in isolation, one would think that the Mental Health Act is all about providing treatment and care of people who have mental illnesses and for other purposes. So it's pretty similar, but it's, if you like, patient orientated. Whereas when we consider the main objects, suddenly we're talking about protecting the community if persons diverted from criminal justice system may be at risk of harming others. There was nothing in the long title about protecting community or criminal justice system or the risk associated with people with mental illness, because the long title was only about treatment. So you can see that sometimes the 2 don't quite match together. They're similar, but they are different. So you can see the difference and you need to read very carefully for those subtle differences. Now, sometimes the short title is in fact a better explanation than the long title. You'd think it'd be the other way around, but take this, and it's in your textbook. The short title of the Act is Tax Laws Amendment, open brackets, Temporary Flood and Cyclone Reconstruction Levy, close brackets, Act 2011. The long title is an act to amend the law relating to taxation and for related purposes. The short title tells you a lot more. It talks about the temporary flood and cyclone reconstruction levy, as opposed to just an act dealing with taxation. So sometimes you need to consider all of these intrinsic aids and then think about which one might be dominant, which one might be subordinate, which are the leading provisions, which are the ones that follow. And again, we're going back to Project Blue Sky. The answer may not be obvious, and you may come to different conclusions to me or others in the class and still be right. So, but you need to make a call. And when you're dealing with statutory interpretation issues, it's all very well to say, well, you look at the long title, you look at the short title, you look at the objects clause, you consider the purpose, and that's how you deal with the statutory interpretation problem. In practice, you need to drill down more deeply, and you need to identify these potential anomalies and make a call. Which one do you think is dominant? Which one is the leading provision? Which is subordinate? Do you understand what I'm getting at? All right. Now let's just go back to that issue of statutory purpose and statutory intent. Sanson at page 90 gives a good example. And when talking about purpose, which of course is the why and the who, says if our purpose was to reach the airport, we may intend to achieve that purpose by, for example, catching a taxi, a train, a bus, a combination, or obtain a lift from someone. So that's the statutory purpose. We're focusing on the why and the who. Statutory interpretation is the what and the how. So have a look at the example in the Act in that regard. Okay, let's go back to looking at sections. Can anyone tell me the preamble to the Mental Health Act? Where is the preamble? You need to know what a preamble is in order to answer that question. Ah, Abby, well done. That was quick. I was giving people a few moments to say it's a trick question. There is none. And why is there no preamble in the Mental Health Act? Short answer is, most of the time we just don't put them in anymore. It's not commonly done these days. Yeah, thank you, Tanya. So the point that I'm making there is that sometimes you can look for something that doesn't exist. If there is a preamble, it's an introductory statement, it sets the scene, it provides some detail about the background, the motivation for the document, and we see preambles commonly in constitutional type documents. We see them in treaties, things of that nature. So preamble and older pieces of legislation. So you may see preambles, but don't be at all surprised if you can't find them in more recent examples of legislation. There was a general rule that if there was a preamble, it didn't form part of the Act itself, but that changed. And in that regard, look at the Commonwealth Acts Interpretation Act, section 13(2)(b). The preamble, if it exists, is now part of the Act. Is everything part of the Act? Is the index part of the Act? Are the schedules part of the Act? The headings? The footnotes? If there's an example in the Act, is that part of the Act? Yes, mostly everything is linked. Mostly. I'm going to leave that vague because I want you to deal with that in your toolkit and have something there that identifies, yes, every word that's written is part of it. If there are some exceptions, please identify those in your toolkit is a good idea. Okay, objects clauses. Well, we looked at section 3 of the Mental Health Act in identifying the main objects, but we may have more than the main objects. In this case, we have a further explanation in terms of the objects. And it's worded on the basis that in addition to the main objects, there is a statement of how these objects are to be achieved, which is subsection 2. Have a look at that for the moment. And you'll see that that, again, expands the basis upon which this legislation is intended to operate. So when an object clause appears in an act, it may certainly be used and must be used in interpretation, but it may not be exhaustive. And you may need to consider other objects from the act as a whole or the objects intended as part of the purpose. The court, of course, may refer to extrinsic materials, and you should too. Second reading speech explanatory memorandum, the notes accompanying the bill, well, we know all that now. Next intrinsic piece of material, definitions, of course, very common. And in this instance, where is the definitions clause section, if there is one? Early, but in a schedule at the end. Yep, section 3. Sorry, section 3.9. Yeah. Isn't it section 9? Section 9. So just be careful. So I think there may have been a reference to part 3, which deals with interpretation, but specifically section 9. But it does go beyond that. So are all the definitions contained in Schedule 3 of the Act? So section 9 correctly refers to Schedule 3, but are all the definitions contained within Schedule 3? Are we getting a yes or a no? Usually there are some definitions within sections. No, says Megan. So not all words are defined in Schedule 3 dictionary. And Gareth says, yes, you've also got to consider sections 10 to 15 inclusive. That's right. So section 10, for example, gives us a very specific definition of mental illness. So it's so important that it has its own section. It's taken out of Schedule 3 and given its own section, as is the case with sections 11 through 15. So that's another little trap. Megan, very good. You read my mind as to the next part of the exercise. So for those that haven't caught on, as Megan did, is it possible that there are definitions in other parts of the Act? And if so, can you find any examples? Schedule 4, says Tim, omissions. Megan, you were really quick with this and correctly identified. There are extra definitions for particular parts in different sections. Say, for example, have a look at section 62. So what does section 62 say? It talks about definitions for chapter 3. And what part is chapter 3? Chapter 3 is within, was the third chapter. So chapter 3, section 62. Also look at section 87. Definitions for chapter 4. So you'll see that at the start of each chapter, there's quite possibly going to be another definition section for the chapter. So chapter, of course, are the big chunks other than the Act itself. Sometimes the definition is included in the individual parts of lengthy legislation, such as the Mental Health Act. Another example, Section 44 capital AB of the Competition and Consumer Act 2010, Commonwealth. So therefore you need to go beyond the general definition section and consider other potential definition sections. Now, Kelly against the Crown, 2004 218 CLR at 216 is authority for this proposition. Troubles me a bit, and that is, a definition is an explanation of a word or a phrase to assist in interpretation. It is not a substantive legislative provision. Okay, so what that means is that we have another distinction that you need to consider within the context of statutory interpretation. We've already talked about dominant and subordinate pieces of legislation or parts of legislation. Now, in accordance with the decision of Kelly, we have to consider that which is substantive legislative provisions and those that are not substantive legislative provisions. Definitions are not substantive legislative provisions. So think about that and see if you can incorporate that as part of your flowchart. We also, last week, I think, talked about words that are exhaustive or non-exhaustive. So there's another distinction. Words that are exhaustive or non-exhaustive. And the same principle applies to statutory definitions. So when you're reading a definition, you're looking for trigger words, words that, I hate to say the phrase gotcha, but if you miss a word that is a trigger word, you may then find that someone says gotcha. We don't want an examiner to say that. So some of the key words are in a definition: means, or includes, or is. They're all key words. So when a definition says mental illness means this, that's different to mental illness includes this. And it's very easy to overlook that key word at the commencement. So when we say something means something, it's exhaustive, it's a complete definition. When we talk about includes, it means these are really just examples. They don't limit the extent to which the definition applies. And we see that, don't we, with the constitutional cases. So if there's a dispute in relation to telecommunications, and it might talk about telex, but it doesn't talk about the internet, we're dealing with that whole justus generum concept of the inclusive nature of a list of words. So watch out for those key words. Now, did everyone read case example 6.1 in the textbook about the captain who was too old to fly, apparently? Did we read that? All right. So John had been a pilot, 747s, for many years as a captain. His employment came to an end when he was reaching, or he turned 60. That was in accordance with policy of Qantas. Pilots were not allowed to continue beyond that age. And the relevant legislative provision was the Industrial Relations Act 1988. Section 170DE said, an employer must not terminate an employee's employment unless there's a valid reason connected with the employee's capacity or conduct. Section 170DF said, an employer must not terminate in employment for any one or more of the following reasons, and that included age. So when we read section 170DE in combination with 170DF, it says you're not allowed to terminate someone's employment unless there's a valid reason, and you can't terminate on the basis of age. Do you see the dilemma here? And Qantas, what have they done? They've terminated a captain with many years' experience because of his age. So does Qantas have a problem? Does John have a good case against Qantas based on the legislative provisions in the Industrial Relations Act? So what do you think? Yes or no? Who's going to win this, John or Qantas? Let's have some votes. So we're saying we're getting the votes. So he did sign a contract. Well, he was, I think so, yes. Okay, so I can see that people have done their reading because we're consistently getting the answer Qantas, and I'm very pleased to see that answer because it does mean that you've done your reading. So why did Qantas win in this particular case? Well, firstly, the case was Qantas Airways against Christie. 1998, 193 CLR 280. Harsh but not unfair. Yep. What's interesting about this case is that there was a divergence of judicial opinion. And it's yet another case that highlights the reality of the situation that three lawyers may read the same thing, two of them go one way, one goes the other way. And that should give you a great freedom to know that you don't necessarily have to get the right answer in any legal problem. Just go through the right mechanisms, identify the appropriate legislation, identify the material facts. But when it comes to applying the law to the facts, you may come to a different conclusion than somebody else, and you're both going to get good marks. That's great, isn't it? It's not like maths. I really like that. But a lot of people stress over it. And the reason I'm saying it is don't stress, make your call, stand by it, and have good logical reasons for coming to the decision. Gareth says, police in Queensland have to retire at 60. Is that right? My goodness. Wow. I didn't know that. That's probably a giveaway that I'm thinking some of the police officers I know, I'm sure they would have been more than 60. Hard lives, I guess. All right, so Qantas Airways and Christie, the trial judge and the High Court majority held that it was an inherent requirement of John's position that he can fly all international routes, and it was insufficient for him to argue that because he could fly to other parts of the world that did not have this preclusion from allowing pilots over 60 from flying, that they should still employ him. The basis of the decision was, no, if you want to be an international pilot, you effectively have to be ready and capable of flying internationally, which means taking into account the laws of the overseas jurisdictions as well as the policy of the local provider, which in this case was no doubt coloured by the provisions of overseas suppliers. I hope that makes sense. All right, so headings. Are headings part of the Act? Yes, they are. What section of the Commonwealth Act says that you can use headings as part of the interpretation? What section? If you're watching this as a recorded session, actively look at this, work through these problems, just like the people live are. We're getting a few different votes. Tuna says 13, and I agree with Tuna. Tuna just beat Gareth, so well done. So section 13, 2D, you can look at the headings. Queensland, do we have a similar provision in the Queensland Acts Interpretation Act? What is the section in the Queensland legislation? Ah, Tuna again, he's on fire. Section 14.2, thank you. When I went to law school in the 70s and early 80s, I was specifically taught not to consider headings as part of the interpretation process. That has been changed. In Queensland, the change was made in June 1991 as an amendment to the Acts Interpretation Act. All right. Exercise 6.2 of your textbook, Lost in Transit. A business contracted a freight company to carry consignment of magazines. On the way, because of the negligent driving, the carrier's delivery vehicle was involved in a collision, and the consignor wanted to recover the loss of goods, but the carrier relied on an exclusion of liability clause in the conditions of carriage. The exclusion clause was challenged by the consignor because of Section 133 of the Motor Vehicles Act 1959, South Australia. And that Act said, any contract where a person contracts in advance out of any right to claim damages for negligence shall, to that extent, be void. So here we have the consignment company purporting to limit the amount of damages, even though the carrier's delivery, the loss was caused as a result of the negligent driving of the carriers. So what happened? The carrier said that Section 133 only applied to bodily injury. That was the argument, that there should be a limitation on the extent to which those words are used. And it was held that within a scheme for third-party insurance directed towards personal injury, the section should indeed be read down so that it only applies to bodily injury. Can anyone tell me the name of the case that dealt with that? And we've talked about it tonight. It was the first thing that we talked about as a hint. K&S Legal Lake City Freighters. Thank you, Gareth. So the High Court majority decided that the section covered property damage as well as personal injuries, and the heading to the part did not limit its operation. Two judges saw the heading as not inappropriate for Section 133, and the provision could not be read down or confined to the subject matter. Another judge simply reasoned Section 133 operated independently of other sections, so the heading did not affect it. So my apologies. It was the argument was that it should be narrowly construed, but the High Court majority held that it should be it should not be limited by the heading. Schedules. Schedules are used to contain detailed information to support a provision, and usually the schedules are in longer pieces of legislation. So, for example, in the Mental Health Act 2016, do we have any schedules? And to what do they relate? Can you tell me what page you'll find this on? I'll be interested to see your technique in finding the schedules. How many schedules and where are they in the Act? We're getting some answers here. Chapter 21, 864. Or was that section 864? Taylor says 3 schedules. Yes. Thank you, Tyler. 3 schedules. Now, where did you find that information? Did you go to the very end and look, or did you go to the index, the contents page? I'd suggest in an Act of this size, always best to go to the contents page, and you'll find the reference to those 3 schedules, in this instance, on page 36. So bear in mind the Act is over 500 pages long. So the 3 schedules in this case relate to information that the applicant's nominee is entitled to receive under an information notice is Schedule 1. Schedule 2, who may appeal to the Mental Health Court, and Schedule 3, as we've already identified previously, dictionary. So those schedules contain substantive provisions about mostly machinery type provisions or definition clauses. Now, what's a margin note or a head note or a footnote? Do we know what those things are? So margin note, something in the margin, we don't see that very often these days. Head note is, if you like, a statement at the start. Additional information is a good way of putting it, Tim, absolutely. And sometimes we see examples as well. So again, think of section 13 of the Commonwealth Act, which provides for all material, which includes notes, such as margin notes, head notes, and footnotes. Punctuation is also potentially relevant. Again, your authority for these propositions, section 13 of the Commonwealth Act, section 14 of the Queensland Act. And sometimes you'll see examples which may be used in interpreting a provision. They don't override the substantive provision, but they're very useful when it comes to interpreting a provision. So in the Penalties and Sentences Act and Corrective Services Act, there's some very detailed provisions in Queensland legislation that deal with the issue of sentencing, and helpfully there's some useful examples that you can use, and that's a very good way of interpreting legislation. And finally, penalties. Unless otherwise stated, all penalties are maximum and are not mandatory periods. So what sections of what pieces of legislation deal with the issue of penalties? So firstly, the Queensland legislation. Any answers yet? If you're watching the recorded session, make sure you go through this carefully. Penalties and Sentences Act, says Gareth. Is there a section, Gareth? Or is it the Acts Interpretation Act? What are the votes? So the question is, what is your authority for the proposition that all penalties are maximums and not mandatory periods unless otherwise stated? Gareth says go to the Penalties and Sentences Act. Tanya agrees. Is there a section? Can we be more specific than that? Or is it the Acts Interpretation Act? All right, I'll get you to look into that. And also, there'll be some homework over the break. Also think about the Commonwealth situation. You may need to consider the Crimes Act as a hint. All right, sorry to leave you with some work to do over the break. Do we have any questions or comments, anything you want to discuss before the break? All good? All right. Now, next week, of course, no lecture. It is a vacation week. And please watch out for news forums where I'll advise you when we're meeting for the live sessions and when I'll have a recorded session for you. I will get the results of the first assessment back for you as soon as possible. And in the meantime, keep building on those toolkits. You'll need that for answering your third assessment, the take-home exam. So the two will work in very closely together. Okay, have a great Christmas, Happy New Year, and please be safe. And I hope everyone does have a great break. All the best, and we'll see you next time. Bye then.